It is not there. Absolutely.
Supplemental list, item number 1.
But I'm just filing a reply to that affidavit they have filed for your lordship's recording, right? And I'll refer to at the time of filing. Copy has been served. Okay. Okay. I'll just take your lordships to a few provisions of law.
I hope that those are also on the scope of limited scope of writ appeal, as decided by the Honorable Supreme Court.
So in fact,
should be based on no evidence. The order should be perverse one. It should be palpably unreasonable. It should be inconsistent with any particular provision of law, because it's a corrective jurisdiction. So that scope are to be kept in mind.
absolutely, absolutely. I'm conscious about it.
Please proceed.
The materials I'll place before lordship will definitely attract all those provisions for your lordships to invoke your lordship jurisdiction.
Yeah.
That is exactly my aim and objective to find the writ appellate. So I would like to take your lordships to one provision relating to the RR policy.
Yeah.
Is part of record.
It's a part of record for it. Otherwise, this is a statutory provision. It's a part of the record. If lordship turns to page 94. The booking is there, madam.
Yes.
Page 94, clause 8, madam.
This book you are holding?
Sir, it is there. In that book, it is there. Rule 20. Then book is there. The RR policy is page 179, Mr. Book.
Which provision?
Odisha Land
No, which provision?
Authority.
Which section?
That is the 2013.
No, that's there. Page 90, it is there. Policy. Photocopy you have next.
RR
Because,
policy,
because,
this book, it is at page
The
number.
policies are 205 in that book, but you also can refer to the brief.
Is in page number 185 in this book. All right. So
No,
Odisha,
225. madam.
Odisha Resettlement and Rehabilitation Policy 2006. This
Yes.
you are referring to.
No, 2006, madam.
Yes.
Yes. 2000. Just wait.
No, I am referring to
Please say it.
clause 8.
Is
Oh,
this
this is-
policy you are referring to or some other policy?
I think same thing.
Same thing, clause 8.
It's the same thing.
No, that's
94 pages and it took it.
Clause 8,
Yeah.
resettlement rehabilitation plan. But it says based on the list approved by the government and option of displaced families.
Clause 8, it deals with rehabilitation assistance.
Clause 8,
Resettlement rehabilitation plan.
No, because this is 2006 policy. Clause 8 is rehabilitation assistance.
No,
Mr. Mishra, hey, I would a copy of a bohiro san
Sir, what is a brief process it है?
No, we want to see the.
190. It is focus for relevance of business. Always, we are very this.
We are having one book, please keep this one and argue from that. Yes, which policy and which page you are referring.
Because in this book, you read section 7, clause 7, just see clause 7.
Yes, but actually
It's
that
see, resettlement and rehabilitation plan is 7, not 8.
So actually, if your worship looks at clause 7, there's a resettlement rehabilitation plan.
It is actually in the book clause 7, but in the brief at page 94, they have stated it clause 8.
Eight.
So therefore, that is
That's the confusion.
Yes.
Actually, clause 7 in the book.
7, yes.
Okay.
7. 7.2 is 7.2 you are relying on.
7.2.
Yes.
But I'm reading the provision for which actually, based on the list approved by the government and option of displaced families, resettlement and rehabilitation plans shall be prepared by the collector for resettlement and rehabilitation after due consultation with the displaced communities in the manner determined by the government. Such plan should address the specific need of women, vulnerable groups, and indigenous community. So same shall be placed before the RPDAC. You also can see the definition of RPDAC is there also. It's a rehabilitation and periphery development advisory committee.
Clause 2 says.
Clause 2 says no physical displacement. So that word is very important. No physical displacement shall be made before completion of the resettlement work as approved by the RPDAC. The certificate of completion of resettlement work will be issued by the collector. But yesterday's affidavit, because I am giving this because the reason is, let's we kindly look at our affidavit is documented. Last page.
Yes.
So kindly turn to page 181, Annexure H is 20th July 2025. The same has been filed.
The one which was filed yesterday.
No.
Which one?
The affidavit filed on 20th July 2025.
Acha.
Where Annexure H is there.
Make sure H. Yes. So that is the
It's a letter from the collector.
reply filed by the respondents.
Yes.
Okay, just a minute. Respondents. What is the date of this one? It is 21/7/25.
It's a letter number 997.
No, this affidavit reply is filed on 21/7/2025, and you are relying on annexure H. Okay. That's what it says.
It says to the general manager MCL Bhubaneswar, it says I am directed to refer the subject cited above. Subject is submission of present status report on completion of Bolanda R&R site for resettlement of 154 project displaced family from Hinsmal Tehsil, Basti. I am directed to refer to the subject cited above and to state that the site plan of Balanda Resettlement Rehabilitation Site was approved in the year 2015. As per the project proponent, MCL is responsible for completing all development works at the RNR site and submitting a detailed completion report for issuance of certificate of completion. So a completion certificate report has to be given on the basis of which the collector is to verify and give a certificate. In accordance with the provision of para 7.2, they have referred to the para also of the ORRP 2006. The 154 project displaced family of village Hinsmal are to be relocated to the Balanda RNR site as per the 2006 ORRP policy. No physical displacement shall be effected prior to the completion of all approved resettlement work. Accordingly, a certificate of completion must be issued by the collector following submission and verification of the detailed completion report. Therefore, it is imperative that provision of 2006 policy are complied with in full to avoid any future legal and procedural complications. You are accordingly requested to furnish a comprehensive completion report. But kindly mark this, to provide a completion report of the Balanda RNR site within 7 days to enable necessary consideration at this end for issue of the certificate of completion. So kindly turn to the next page.
No, Mr. Please, sir, just
Sir.
the previous paragraph.
Sir.
So it should be completion of all approved resettlement work.
Yes.
So what is that approved resettlement work?
So that is, if you also look at the book, that is Appendix Schedule 3.
No, it may vary from case to case also. Suppose there is the parties have agreed that this should be, we are acceptable to this resettlement.
Sir.
So, and the authorities have completed that. So
No,
you cannot say that there are some other thing in this policy, so they are also required to do it. Is it your case?
If you also kindly see the schedule, third schedule in the book.
Yes.
Maybe page 82.
If you are holding that book, please tell us.
It is-
That book.
Page number in there.
Because I'm guessing it.
Just tell us the book page number, that will be here.
Page 82.
82.
82. Okay.
Yes.
Okay.
Third schedule. Yes.
Page 82, Lord, got it.
That is provision of infrastructure.
Resettlement of populations. This has been referred to at the Supreme Court also. I'll take your receipt to that. So that. For resettlement of populations, the following infrastructural facilities and basic minimum amenities are to be provided at the cost of requisitioning authority to ensure that resettlement population in the new village or colony can secure for themselves a reasonable standard of community life and can attempt to minimize the trauma involved in displacement. Here's the question of displacement.
Yes.
A reasonable habitable planned settlement would have, as a minimum, the following facilities and resources as appropriate. But they have indicated what are the things. One, road within the resettlement village, and all-weather road linked to nearest Oka road, passengers and easement rights for all the resettled families be adequately arranged. Two, proper drainage as well as sanitation plan executed before physical resettlement. Three,
All these are given.
yes,
At read.
everything are given, sir.
Hmm.
All the details are given.
Hmm.
This has been taken note by the Supreme Court also that.
Yeah.
But these are the provisions to be complied with
Hmm.
before a resettlement.
This is
or
the
certificate can be-
this is the approved plan according.
Right, approved plan, as per the approved plan. Also the approved plan also, I am filing it. But then can you look at, this was given on 10/6/2025. Am I clear, Lord?
Yes.
But the judgment of the single judge was passed in 2015. At that time, Sir, this is 25, they say you give the completion report to provide a certificate. It was not complete at that time. Therefore, this is one of the ground for which the order of the Honorable Single Judge is faulted with, which cannot be deemed to be correct approach while dealing with the matter. It
Okay,
is
now
not that
thereafter what has happened? We are concerned with, you are right that at that point of time, but
they have indicated here in this letter,
yes.
the plan has been approved in 2015.
No. After this, during the pendency of the writ
bill,
appeal,
right.
if you will find the that advocate commissioner had gone and he had
So I am highly obliged. I'll come to that. Next point is that
he had pointed out some defects in your favor.
Yes.
That these
Right.
are, but now the recent objection which has been filed,
Yes.
that is, I think that is dated 2/9/2025.
Yes.
Right. Almost recent one.
Yes.
That was filed by Sanjay Kumar De.
Right.
I think you have got the copy of that.
Yesterday's affidavit.
No, I don't. It is written as objection filed by the respondent NCL to the terms of settlement dated 8/8 so and so,
No, that is-
the appellants. And
I'll show that. I'll show that.
was it 2/9/2025 is the, it was filed on, yes, 2nd September 25.
Yesterday, actually, day before yesterday.
Yes, if we'll come to that,
I'm coming there. I have filed the affidavit to that day, today.
and another thing,
Sir,
Mr.
So
Mishra,
kindly look at that affidavit.
Mr. Mishra, please also, just before that, you just come to reply which has been filed on 27/2025. That you also come.
27, actually, I refer to that. I refer to that.
No, why we say so? Because it would be easier for you that whether that has been complied with or not. It is written like this, that a reply filed by the respondents to the IN number
2913
of 2025 and IN number 2939 of 25.
Correct.
So if you come to that, you will find that in paragraph number 12, please come to that. We are just clearing of our doubt, then we will.
Para 12.
Para 12.
In respect of serial number 3, it is submitted that all the applicant except 29 and 34 of the list given, the list is given below.
Have been allotted plots,
Yes.
the details of which are as follows.
Yes,
So,
Lord. Allotted
name
plots.
given, plot number given, all these things have been given, right?
Correct.
Now you come to the
13.
next paragraph is
13.
paragraph, just a minute. Yes. Ah, 13.
Yes.
That indicates, please come to that. Copies of the plot allotments letters, they have annexed it as annexure A series in that paragraph 12. And in paragraph 13, you got it that, Mr. Mishra? Are you having that copy with you?
Yes, yes.
Okay, please come to paragraph 13.
13 I'm there.
Yes, that is there, that 97 appellants, in addition to the allocation of plots, MCL quarter accommodation has been
Yes,
provided.
correct.
So that is there.
That is transit accommodation.
Right, obviously. So now if you come to the what they have provided according to them, that is stated. Then paragraph 14, you say that
Page 14.
Serial number 5 is concerned, MCL also agreed to adjust the period of absence due to termination of service.
okay. Then please come to paragraph number 19.
Yes. Out of 3 subject displaced family, 223 have opted to cash compensation in lieu of resettlement plot, have voluntarily vacated their land. Both agriculture and dwelling house, given physical possession of the same to the MCL. The rest 150, that is, we are within that 150,
Yes.
have been allotted with resettlement plots. It is further submitted that all the appellants have been allotted the resettlement plot. Only appellant number 34 has cash compensation of 6,32,000 in lieu of plot, and appellant 29 is not eligible for resettlement plot.
Okay, so this is their averments that
Yes,
these are the plot numbers which have been allotted to the appellants. Now, so far as this basic amenities which you are referring to that thing, that has been clarified. I think you come to the affidavit filed by MCL, that is 16/6/2025.
6-2.
16/6. That is the affidavit filed by the affidavit filed by the respondents. No, there is one.
3/10/23.
No, it is
17/6.
It is 17/6.
Yes.
Please come to that. 17/6, they have actually given their reply to the advocates commissioner, pointed out that these things have not been done.
Right.
So they have quoted that what are the observation of the advocate commission, and then they have stated what they have done
Yes.
thereafter. So if you'll find, you say first it has been shown that come to paragraph number 3. Please come to paragraph 3. They have given the observation, then they have what they have done thereafter.
Right.
That particular affidavit which has been filed by MCL on
Yes.
17/6/2025.
In pursuance of the aforesaid order,
Right.
dated 22/9/2023, the Ladder Advocate Commissioner visited village Hansmal and resettlement site near Vanda so on 14/10/2023. With regard to the observation made by Ladder Advocate
Right,
Commission,
and they have replied it to that.
that moreover 13 plots which have been encroached by Nigavananda Little Star School, electric poles, wires have not been erected. It is pertinent to mention here that pursuant to the direction of the Honorable High Court, passed in writ petition so-and-so himself evicted and demolished encroached area of NLS school on 24/12/24.
So this is, they have done thereafter. After the-
24/12/2024. After eviction, MCL authorities have issued letter 7/1/25 and 26/5/25 to the allottees to take over the possession of 13 plots, but they are not showing interest to take possession of the said 13 plots.
These 13 plots were there in that was there.
School was there.
That was demolished, and they have, according to them, they have
Offering the plot.
offering. Okay, now next paragraph.
So far as the erection of electric poles, but I'll just pause a minute to one sentence. I'll say that showing the plot to take possession is no meaning in fact, unless the other amenities are provided.
Right, that is,
Right.
first of all, we are whether the plots have been allotted. Allotted means whether it
Plotting.
is specified.
Plot, yes.
Then about the other basic amenities, like as you say, drinking water, electric.
So far as the electric poles and cable wires in the rest part of the land, including 13 plots, MCL authorities along with the authorities of Tata Power visited the spot on 12/6/2025, demarcated the spot where the electric poles have to be erected. Sir, the date may be kindly noted.
Yes, 12/6/20.
12/6/June/2025. Demarcated the spot where the electric poles have to be erected as discussed with Tata Power. All the pending works relating to erection of the electric poles and cable wire for all the plots will be erected within 1 month time. Further, it is submitted that no cable wire are in state of despair as the cable used to wiring area of aerial bunch cable were to be strengthened during the completion of the rest part. The observation of London Advocate Commission regarding the water supply,
Now what to supply.
it is respectfully submitted that the overhead tank already been constructed. The same is functional. The superintending engineer, Talchet Swinso, dated 10/6/2025, have informed the general manager, Bhubaneswar area, stating that the rural pipe water supply to RS site for the village Hansmal at Koil Nagar in front of Varanda village has been completed and at the stage of commissioning with the following details. The details are given.
That photograph has also been given that
Yes.
water tank.
It is
Yes.
pertinent mentioned there, main water pipe have already been laid on the RF site, and the supply of water to the individual plots can be provided through functional household tap connection.
So obviously there is no construction.
Right. Advocate Commission regarding sewage drainage, it is respected that the special drain has already been constructed for taking out the wastewater from the neighboring MCL rescue station of the 3 plots as suggested of the London Commission. Observation Commission regarding plot leveling, it is respected submitted. All the RR plots have been labeled to the road level, including 13 plots, which are enclosed by NSL. The observation of the Advocate Commission regarding plot demarcation of the RR work, it is submitted that there is no dispute regarding demarcation of the plot between allottees, MCL, since several allottees have already constructed their house in RR site. It is pertinent to mention here that after eviction of NLS school, MCL have demarcated 13 plots by putting cement pillars. Later dated 7/1/2025, 26/5/25 have been issued to respective 13 allottees to take over possession of their allotted plots. Till that they are not showing interest to take possession. Then sir, former that the observation of the Advocate Commission with regard to road connection, it is expected submitted that the complete road connection to the individual plots have been completed, except the 13 plots which are enclosed by NL school. So far as other development with regard to construction of balanced concrete road, community center, primary health center, temple, marketplace, Anganwadi center, Dodamandap, remaining main drain, 90 mm to box culvert, Kothanagar has been completed. Tender has been floated on 22/1/2025. I'll show the tender, Lordship. It is humbly submitted that the above mentioned tender is with regard to ancillary development of the resettlement site, and the construction of the same will be completed by the time houses are constructed by the appellant over RR site. It is respectfully submitted that all the appellants have been provided with RR benefits, including employment benefit. They have been allotted resettlement and voluntary resettlement site for the temporary, and it is humbly submitted that in the meantime, those opposite parties have issued notice on 12/6/25 to many of the appellants for acceptance of a gratia of 5 lakhs approved in favor of their children who are minor on the cut-off date of acquisition of land for RR benefit, also to vacate the premises by handing over the possession. This is one of the issues for which the interim order has been issued, because they want to ask the children to vacate, the entire family will be gone in fact. Reply with issue. Sir, I would like to show in response to this matter. Kindly look at the today's affidavit, which I have filed.
So, if we, after going through this particular affidavit, we are of this impression that when the Advocate Commission visited the place, that spot, as per the order of this court, he pointed out in the report that these are the things, deficiencies, and it needs to be. But simultaneously, one thing, very important thing he has stated in that report. If you come to that report, please come to the last paragraph.
9.
Page 9.
Yeah.
No, that is this paragraph number 4, page 9, paragraph 4.
Yes. Observation regarding position of the village. Observation regarding position of the village. But I humbly submit that it is a proactive feeling of the Advocate Commission to express that, but the villagers do not feel so, nor it is imperative on that ground. But here, the Commission is to see and visit and give a report on the specifications given. He has over anxiety to express something which was not called for to be informed.
No, what he has seen at the spot, that this is the state of affair, and it needs to be, of course, Now, let us be, Mr.
With
Mitra,
due respect, such a contingency still doesn't arise.
It is
With due
very,
respect, sir.
very unsafe that way, forcibly.
no,
Sir, I think,
we'll hear, Mr. Advocate General, we'll hear you. No, we are saying that if
my
we-
friend is also, he is in a position where I cannot.
we are expressing because if there is danger to the lives of the family members and they have made some arrangement like the quarters have been allotted and that place which you are rightly said that everything is not complete, that's why completion certificate. So why are you the rest person where they are not coming to the quarters?
I
And
have
so
given a
that-
suggestion in the affidavit also. I have given a suggestion in the affidavit also.
Because if you stick to your demand, that's all right. That will be definitely in terms of the that policy, that third schedule, it is they are duty bound to fill it up on completion. But the thing is that if the risk is there to the life for which some persons have already removed from the place,
True.
so question is
Sir, two things are already moved to the transit house.
transit out.
Sir, if you also permit me to, I'll say, with no comment from the advocate.
I am not coming.
But there are transit houses where somewhere it is 2 rooms are available. Transit houses with 5 into 5, one single room is accommodation is given. The kind of thing, an entire family for 200, 500 years residing in a house with 4 family members. Can this reside in this one room? My lord?
No, we do not know that how, what is that room condition?
It is there, my lord. That's the report from the villagers who came. I to ask them particularly, what are the size of those transit houses? Which some are 8 into 10, some are 8 into 8, some are 7 into 7. But 4, 5 members, father, mother, children, all these cattle and everything. But all is not possible to shift. So therefore they are approaching the authorities that you give us the entire site, we will shift. We do not want to stand in the way for this development work. I have also given report, they have profited, but there is no question of any, so far the income is concerned of MCL, it has increased leaps and bounds because we have vacated entire thing except this homestay. We have vacated everything. Our agricultural land is gone.
Yes, agricultural land, that is gone.
And interestingly, they are not able to develop the area because a portion of it is a forest land. They are not getting clearance from the forest department.
No, that
So that is the reason they want to vacate. We are also ready to vacate, madam. I candidly confess and we say we can't resist not to vacate, but provide us with regard to
Advocate General,
2 months, a
you
timeline may
know
be
that
fixed.
letter which has been given by the collector, because that completion certificate is required.
Yes.
So we are sure that in terms of this third schedule, which has been pointed out, so everything is not complete. You cannot deny it that these
No, but,
things which are the basic amenities are required. And that is not fully complete. You have done a lot, I can say, that we can say that it is that the plots have been plotted like that, and water tank is there, some concrete road is there, and sites have been also selected that where would be the school or the dispensary, all these things. But that provision, how can you get over that unless it is so that it is totally complete and the completion certificate? Obviously, you are not issuing that certificate because it is not complete in all
It
respects.
has been issued.
No, that is issued, that the recent affidavit which you have filed.
Yes.
Let's see, but this completion certificate is very vague. Completion certificate means it should be, detailing out what are the facility you have given. Simply one line completion certificate.
No, it is earlier there. It is to be read along with the other affidavits. my lord. All those 2 affidavits which my
So
lord
the
Justice Sahoo
completion
referred to.
certificate itself should be self-explanatory.
No, that's correct. No, it is not. It is only a certificate.
You
of
are
complete-
relying on that page number 7.
Page
of
number
that-
7.
Yes, 7.
Right.
Page number
So
7.
if it is, Mr. Mishra, I think we have got that, sir.
Yes.
Yesterday, the affidavit which was filed,
Come to page
there
number
is an
7.
annexure, 7.
That is the completion certificate.
Yes.
This is the completion certificate.
Let your lordship
is-
may I read the
They
content?
have annexed
No,
that
just-
affidavit.
No, they say they complied 7.2.
Yes.
Now, the objection which you had, 7.2 is not complied. Now they have
It
complied.
is
That's
not
what
a,
that
no,
is.
no.
Sir, it has
That
not
is
been
the
complied.
only thing.
Reason, sir,
Because it
reason is
doesn't
there.
say
No.
that the details are to be contained in the completion certificate. Without completion, your lordship may look at the first paragraph. With reference to your status report dated so and so, it has been addressed to the general manager MCL. It is
Mr. Mishra
noted that
says
the-
that he, Mr. Lion Advocate General, he submitted that is not available with you.
No, it is there. It is very much there. She was referring to this.
Affidavit.
Yes.
Recent.
Page number 7. Dated 13/8/2025. Okay, please.
Got
Yes,
it.
Mr. Lion Advocate General,
Yes.
please continue.
Milord, may I read the full affidavit? Milord, this full affidavit contains everything which is to be answered by the Milord, your lordship, with reference to your status report dated so and so. It is stated that the mandatory R&R entitlements have been sanctioned in favor of the project displaced families of the village Hensumal. Thus, the same has been confirmed by the sub-collector Talche by his letter number so and so dated 23rd June 2025. Therefore, the certificate of completion of the resettlement and rehabilitation R&R of the project displaced families is issued under the provisions of para 7.2 of the policy, and 7.2 says that a certificate of completion is to be issued. So it is not that it should contain the details of the facility, etc., which has been granted, which aspect has been exhaustively dealt with by the
What
two
he says
affidavits.
is as per the approved plan.
Yes.
It has to be.
As per the
certificate has to be
plan.
given.
So these two affidavits which my Lord Justice Sahoo was referring to, they are quite exhaustive, my Lord. Everything has been done, and whatever, my Lord, remains, all those things have also been tendered. The moment they construct and complete the houses, all those facilities will be ready, my Lord. We have given, my Lord, detailed it out in the affidavit of No, this not this. My Lord, this is a very detailed affidavit. And the advocate commissioner, which your lordship directed to visit the spot, my lord, the entire thing has been complied with. Entire thing. He has
pointed
1,
out
2,
some
3, 4.
deficiencies.
That has been answered in the affidavit. My lord, I did not go to this in detail.
No.
But
But,
I did not go to this in
Mr.
detail.
Mr. Mishra, once this certificate has been issued,
That's correct.
and if you say that it has not been done, but how can in a writ appeal
The
will
court
decide
can
all
go
this?
into this.
This simple thing, you said that completion certificate has not been issued. Now the certificate is before us in page number 7.
So
Which-
that is exactly my point, sir. So that is exactly my point. If your lordship looks at 7.2, so kindly look 7.2 again.
Does it indicate that all
Yes.
the details should be indicated
Yes,
there?
kindly see
Let
that.
us see.
Kindly see that.
Please, what is that page number you said?
7.2
181.
is very clear.
No. Schedule.
It is
It is
one-
hard schedule.
No, thank
Watch
you,
out.
thank you. 181.
If you can quickly see.
Which page was that? 191?
Sir, 94. Oh, in the book,
190.
190.
190.
Act page 191.
Yes, 190. Yes. No, physical displacement.
So first sentence is,
It's not book.
no physical displacement shall be made before completion of resettlement work as approved.
So now it is issued.
That approval, what is that approval forwarding letter to the collector? The RPDSC has to
But
approve.
according
No,
to
no,
you,
that has
this,
been
this
done.
completion letter should precede the approval.
Yes. It is not an empty formality, my lord.
No, that has been done. The first part has also been complied with.
No, that is
Not that
exactly-
it's a letter
The
in
letter doesn't
isolation.
say so.
No, they have referred to the GM's letter.
Do you have it?
Yes. So
Do you
look
have
at
the
this.
approval letter?
Milord, they have referred to the GM's letter for the GM ka letter. Talcher, Milord, he has referred to 3 letters. First of all, the letter dated 19/6/2025 of the status report that the mandatory R&R entitlements have been sanctioned in favor of the project displaced by the families, that is the letter of the general manager MCL. The number 2 letter which he has referred to is letter number 1920 of the sub-collector,
Yes.
that it has already been granted. So after that, my lord, on perusal of this,
Three words.
whatever, it can't be,
No,
my lord,
this-
entire thing,
No, no.
everything there cannot be a voluminous
No,
report.
RPDAC approval. Where is
Yes,
RPDAC?
RPDSC has, my lord, approved the entire
Where
project.
is that letter?
My lord, where is that? Just show this RPDSC. ka approval.
RPDAC.
Milord, that has been done, Milord, long since. And Milord, everything has been detailed out in this affidavit. We have everything stated on oath that these are the,
Is it there in the on the record?
Facilities to provide you.
Milord, their only contention was the plots were not allotted. Milord, 19/6/25, annexure J at 182 page of the affidavit dated 17/6/2025, Milord, which your lordship was referring to para 12, 13, plots allotted, etc. Milord, that's lengthy affidavit of 17/6/2025.
But in this affidavit, yesterday's affidavit which you have filed, there also you have not said anywhere regarding RPDAC approval. Have you said anything?
RPDSC approval, Milord, it is already there in the earlier affidavit. Milord, may I place this?
Please. That is his contention that the, this completion certificate. should
Milord, we
be
wrote,
to-
Milord, 10.
Referring to that,
Preceding the.
Milord, your lordship will kindly look at.
June the collector
Just-
writes.
Just.
Even the detailed conclusion report.
No, yes, Milord, annexure H as page 181. Milord, the collector, by his letter dated 10/6/2025 at annexure H, page 181, you will lordship would find submission of present status report on completion of Balanda R&R site for resettlement of 154 project displaced families from Hensumal, Tahsil, Basti. I am directed to refer to the subject cited above and to state that the site plan of the Balanda resettlement, etc., was approved in the year 2015. As the project proponent, MCL is responsible for completing all development works at the R&R site and submitting a detailed completion report for issuance of the certificate of completion in accordance with the provisions of para 7(2) of the Orissa Resettlement and Rehabilitation Policy 2006. The 154 project displaced families of village Swanfield are to be relocated to the Balanda R&R site. As per Rehabilitation Policy 2006, no physical displacement shall be effected prior to the completion of all approved resettlement works. Accordingly, a certificate of completion must be issued by the collector following the submission and verification of the detailed completion report. Therefore, it is imperative that the provisions of this one 2006 are complied with in full to avoid any future legal or procedural complications. You are accordingly requested to furnish a comprehensive completion report of the Balanda site within 7 days to enable necessary consideration at the same for issuance of the certificate of completion.
Next page.
Followed by that, yes, Milord, it contains a report. It's a
Read it.
forwarding letter only.
Read the next one.
No, it's a forwarding report. Everything has been detailed.
Just read it.
So, Milord, this is regarding the status report on resettlement rehabilitation from the Khensmal Bhubaneswar area. In this connection, we'd like to submit the following facts for your kind consideration. Village Swanso consists of 377 PDFs, out of which 223 PDFs have opted for cash compensation in lieu of resettlement plot. Balance 154 PDFs have been allotted plots at the Swanso acre land to each PDF at R&R site Balanda as per their own demand. No valid R&R demand is pending with the land acquisition authority. Nothing, Milord, it can't be exhaustive. He is, Milord, reopening everything.
This letter also doesn't say
No, Milord,
whether the
nothing is
amenities
pending.
are provided or anything.
Everything has been provided, Milord. They want to bargain more. Milord, in the last discussion, as per your lordship's direction, they, Milord, came out with novel proposals. Employment should be given to each one of us.
Those things are-
14 lakhs more should be paid to us.
Employment
Like
has
this,
already
Milord.
been given.
No, it has already been given.
No,
Employment,
only the-
Milord, they are demanding employment in favor of their children who were not even born when the land was acquired. They say in the meantime they have been born, they have become major, so therefore you provide. No, that is their demand. In the time of negotiation, they said that provide employment. He was 14.5 lakhs of rupees again for the construction of house. Milord, we can't travel beyond the scheme or beyond the
Right,
policy.
only you satisfy us that the basic amenities are provided and everything is in place. That's all.
Yes, Milord, that is what the collector's certificate is there, and we have stated it also.
That
Milord,
approval,
whatever in
that approval,
response-
if you can show us,
Milord,
this PDTHA approval.
Milord, huh?
That's the end of the matter. Show us that approval. That is end of the matter. We'll close
Yes, Milord, no approval, one aspect, the affidavit which we filed after the submission of the report of the pleader commission, Milord, that affidavit, your lordship was now referring to point. These are the deficiencies, Milord, which have been addressed. That is on oath we have stated before your lordship. Milord, after that affidavit also, another affidavit was filed by us. Two affidavits. 17/6/2025. Milord, this affidavit your lordship have already referred to. I need not 20th July 2025, Milord. In June we filed one affidavit. In July we filed an affidavit. And whatever findings, etc., was, Milord, given by the pleader commission, everything point-wise has been complied with. Only a few families, Milord, everybody has also vacated. They now demand that these are the things are our demands. You comply with it, which is completely beyond the scope of the policy or under policy. Otherwise, Milord, they are creating trouble. Nobody has objection except those petitioners, Milord, who are litigating since 2015. And Milord, they are traveling beyond the scope of the writ petition. Milord, if the Lawrence single judge judgment your lordship would look at, Milord, there also the finding was in 2015 everything was done. But still then in the appellate stage, your lordship directed for appointment of a pleader commission. He visited the spot and your lordship rightly pointed out in the concluding remark he has stated that it is unsafe because the age of the mines is only 100 meters away from this village. They are not, Milord, in fact, physically staying there. Only the dilapidated houses are there, 7-8 families. They are, Milord, forcibly occupying that area. Nobody is staying there. And the quarter has been provided by the MCL for those who opted alternate accommodation. It is not 5-8 or 5-5, factually incorrect. Good houses have been given. They are still occupying, Milord, even after completion of the houses. After completion, they are not leaving the quarters. Have come to this court, they got some stay order also in some of the matters like this. They are completely playing hide and seek. It's a national project and coal, your lordship knows, is a vital component for production of energy. It is against national interest and they are being instigated by some local leaders and not living, bargaining every time, Milord, they are coming out with a bargain and Milord, in the name of resettlement package, etc., which has been given more, Milord. There was a meeting under the chairmanship of the chief secretary also. Milord, there was a chief secretary ka meeting dekha.
Mr. Mishra, one thing just.
Milord, page 8 of one affidavit.
Mr. Learned Advocate General, just one.
Yes. Milord, may I
Just now a certificate of completion has come on record.
Yes.
Which is dated 13/8/2025. You are disputing it.
No, sir,
You say that the certificate
may I?
has not taken into account this RPDAC approval.
No report is there. Sir, absolutely
No, it's all right. But whether we are not going beyond the scope of that writ petition which was filed.
Absolutely not. Absolutely
No.
not. With you, I'll satisfy that one. Has to take a practical aspect of it.
It in fact gives you a press cause of action. That's what.
Milord, every time there is an affidavit, there is a counter affidavit, there is an objection.
Sir, kindly
Every day,
look at
Milord,
those
it can go like
photographs. It has
this.
been taken. Kindly look at those.
Not
photographs.
less than 20 affidavits are being filed one after
Kindly
another.
look
We
at
are
the
filing an
photographs.
affidavit, he is filing an objection.
Kindly
Then
look at
again,
the
we are
photographs.
coming out with another affidavit. This is not the way. photo দেখে
আমি ওটা করি।
daily কোনো pleader
As we can find, sir.
these are all disputed
Sir, this is
question of
picture
fact.
today.
Whatever remaining grievance he has, that is a tribunal.
See,
He
the
could have
house has been
approached there.
complete.
Recapitulation
Everything
is not the
complete.
forum. Every day he is enlarging
So
the
can you see
scope
the
of the
photograph?
writ petition.
But they have to be very
And those
practical.
photographs are not to be assessed by an appellate court, by
Yes,
the
yes.
High Court.
Yes, yes.
It is not a civil court that.
Sir, I am showing.
He was showing that something, so these are, how can we adjudicate?
That's
in
correct.
appeal?
Absolutely.
Adjudication on this period.
So now the completion certificate has been issued.
Your worship is to see that these are complied with. But law is there that it has to be complied because as per statutory provision. That you have to follow that. You cannot just avoid that and say, we have done this, we have done this, but.
According to you, this collector has issued this certificate not in consonance with.
No, sir.
So that is to be challenged. How can it be adjudicated in a?
What I'm saying, 2000 paradise tender has been floated in July. Can you see that? So July is a tender floated of 28 crores to complete the project.
No, complete the project for the purpose of providing you the amenity.
Sir,
You are
what
not
amenity?
sitting there. How do you expect that amenity
What-
would
what
be
are the
ready thereafter
amenities,
you will
sir?
go?
What is the amenity?
You
Can you
first
see that?
vacate, so thereafter
Sir, I
those
think
construction
affidavit
will.
of place 20
January, Milad, 7 months are passed.
20 of the affidavit.
Milad, 15 years,
Just a minute.
long 15 years, he has
Just
been
a minute, sir.
litigating, stalling
Page
the
20
project.
of the project.
After getting everything, Milad, since 2007, they have already got.
Page 20.
Not now. Every day they are coming out with a new bargain, Milord, every day, and by shape of affidavit, but still then, Milord, pursuant to your lordship's direction, we obeyed it, and the pleader commission's deficiency, whatever were pointed out, we complied with it.
It has not been.
The affidavit
I have
is
given
quite
reply to that.
exhaustive and detailed, but still then,
Page
Milord, he
20.
raises many disputed
the
questions
tender.
of fact.
Side out is side plan.
You say tender was floated, where is that?
Tender floated.
We have stated that, Milord, in January in our affidavit.
When did it start?
Sir, tender document. It is.
January.
That's not there.
Now.
The kind look at the tender document. Sir, collector is under his control. He will lose his
Collector?
service if he doesn't give the certificate.
Once upon a time, you were also controlling those officers for 5 years.
No, sir.
Why are you accusing?
No.
That is why exactly from the very
Development
beginning,
not done is
Uh,
phase 20.
Mr. Mishra, I told that we are to keep in view what is the scope of writ appeal. You are going.
I'm arguing, I'm not arguing beyond the purview of your
This thing that has not been.
So
done,
can you look
that-
at the judgment? So Honorable Supreme Court has dealt with a matter similar matter. Can you have a look at the judgment?
We cannot doubt this, at least the letter has been issued by the, we cannot even ask for why have you issued the letter? You are required to do,
Why?
these are all
Why, sir?
going beyond the scope of.
No, I'm not saying why, but he has to comply 7(2).
RPDSC
mentioned that it
approval
has-
you place on record, we will close it.
Yes.
Where is
then
that
file the affidavit
approval?
support.
RPDS, DSC approval.
RPDSC approval.
That's the only thing we need to see. That's all. It is
So
approved,
please,
then
report has
we
to be
need,
given.
because see, we can't go into the factual dispute
Right.
in the writ appeal.
Sir,
And the factual things will be verified by the committee,
Sir,
RPDS committee. If RPDS committee does it, then we will close it. We can't go into all this.
and then file it.
But RPDSC is approved since 2015, Milord.
No.
No, the Sobhana.
15
We'll produce that, Milord, we'll find.
Now, on the 13th meeting of RPDS,
Yes,
that he has filed at page 35,
right.
and the RPDS,
Everything, Milord, has been approved.
no,
I produce-
kindly see page 35 of the affidavit which they filed.
Yes.
Let's see. subsequent to this, whether any RPDS meeting has taken place or not. If it has taken place, the end of the matter. We need not go into all these things.
Recommendation.
Project plan.
Project plan of that.
Incentive 10 lakh. So affidavit with a proposal this for solving the matter.
Yeah.
Nice. It's not there. Not there.
But everything is there. Why are you saying that now? Etc. Your Lordship knows that whatever, let us assume, Miller, there are certain things that to be done. Let us assume. So it is always done in a phased way. So now, till now, Miller, they are not leaving the houses. After receipt of compensation and etc., they are, and Miller, everything, compensation
We are
and
not on that.
house
at all.
construction.
We are not on that. Whether
That's
the settlement
correct.
is
And
done
the
or not. That's
amenities,
the-
Milord, etc., whatever was to be done, we have stated that tender has been floated, a water tank has been constructed, a road has been constructed, everything, Milord, all amenities. Whatever electricity has been provided, whatever is left, Milord, it is in the process, it was. In the month of January, the tender was floated. In the meantime, what is the progress? Incidentally, the collector is there today. Milord, let me discuss with him. Your Lordship may close it. We will file a report that everything, and that is, Milord.
Collector is here.
Collector is here today. I think he had,
Call.
yes, call to collector. Full number.
Why the collector?
Hope I'm not interrupting in his argument. Let me.
Yes.
Yes.
Sir, Karim, sir, you have all the way to Delhi.
No, no problem. I should not. Now, the entire issue, one thing is very clear. The compensation has been paid. The rest of whatever the other benefits sites have been allotted, that entire list is already placed before the court. Keep that away. That's one part of it. Now, kindly go to the impugned letter, which is actually impugned in the writ petition. To what extent, how it transferred into this particular letter, kindly turn to that annexure 13.
That you have the
Of the writ appeal.
writ appeal.
Yes.
Yes.
That's the page 107.
Yes.
That is the impugned letter in the writ petition.
Writ petition.
Yes, kindly take it. The MCL management has already. Yeah, I'm sorry. Yes. The MCL management has already decided to fulfill the following demands of the so-and-so villagers. What was the demand? Kindly make a note of it. Reinstatement of all terminated employees without break in service and with immediate effect. Done. Comply. The villagers will not have to submit affidavit for the same. Done. MCL has already agreed for allotment of R&R site situated in front of Balanda College and has been decided in the RP so-and-so meeting on 19/7/2014. MCL will allot plot to the villagers at R&R site in front of Balanda Village College, duly decided by RPCL for obtaining clearance from Government of India and diversion of forest if required. MCL management has already initiated action before the appropriate authority for allotment of the plots. That has been done. Sites have been allotted. The villagers who are not having company accommodation will be allotted company's quarters on priority basis and in minimum possible time and as decided in sub-collectors meeting on 6/7/2014. MCS also agreed to adjust the period of absence due to termination from service with payment of leave to credit with individual. So all these things have been completed. And what they were agitated is the next para. In view of the above, the villagers are requested to join their duties as per the undersigned dated 22/7/2014, issued to their residential address as per the available record and vacate home and homestead of land and hand over it to MCL for continuation of mining operations so and so, latest by 31/10/2014. They were agitated by 31/10/2014. The deadline fixed in this letter that was not acceptable to them. To that extent, they filed the writ petition. Now, kindly go to the previous letter, that is Annexure R12. That is the letter which was issued. Referable to at yes, page number 106.
106.
106.
Yes.
In pursuance with the minutes meeting dated 6/7/2014, with regard to the resettlement of the residents of village so and the subsequent letters dated so, as well as the meeting held on 6/7/2014, referred to couple of series of meetings under the aegis of Honorable Minister for Energy, Government of Odisha. You are hereby reinstated to the post of so with immediate effect. You are required to comply the agreed points of the meeting stated in the referred minutes of the meeting, and after reinstatement in the service, you and any of your family members are to refrain from any agitation means and hand over the physical possession of your house and homestead land structures to MCL latest by 31/10/2014 in line with the agreed points of so and so. That was now kindly go to the agreed meeting, which was agreed between the parties. That is referable at Annexure 6, page number 82.
Yes, this is agreed.
Yes, meeting with the residents of so and so, so and so. Let's say 2014 meeting. The meeting was convened, yes, meeting was convened today, that is on 6/7/2014 at 11 a.m. on the office of the sub-collector culture with the following assurances accorded to the agitationists who are on strike for protesting the retrenchment of 127 employees. The residents have been intermittently resorting to protect their different forms of demanding reinstatement. MCL authorities, on the other hand, continue holding the stand of the vacation of the homestead land by the villagers and setting up of the rehabilitation colony at any other alternative site other than the so and so, if approved by the so and so, so and so. They were agitating. They wanted reinstatement at the first instance, and the alternative site to be provided.
The underlying thing is if approved by RPDS.
Yes. Now kindly come down to what was agreed upon. Then kindly skip the next two paras. Then the Honorable MLA Culture. The Honorable MLA Culture suggested that for the sake of congeniality and the ambience of discussion and solution to the problem set out in the employees should be put back to the role at the first instance. That is the first one. He further mentioned that the making over possession of the homestead land could be planned after finalization of the resettlement site. The sub-collector apprised all the concerned with regard to the steps to be taken so and so. Demarcation of the land is needed to be determined with the precision so and so. Then finally, the last. However, in the meantime, PLA so has been placed in the organ of so and so PRB to address the micro issues in fitness of things we saw across the following was decided. MCL authorities will reinstate the retrenched so and so on by 2014. There will be no break of service. Collector and Anugo will be requested to convene the meeting of so and so at the earliest to discuss and finalize the principles of rehabilitation site. The MCL will start taking measures towards rendering the site hassle-free from legal perspective. The MCL authorities will arrange interim accommodation as would be decided by the PSLR after it's finalized in the principle, and extension of such facilities to the villagers to start vacate and homes. Our villagers will start vacating the homesteads. It was agreed upon in couple of meetings that they have to vacate the occupied place because it's already vested with the government. It's a government property. Land is vested by virtue of the section 10, 11, 12 notification issued under the Act. It is a government property. However, to accommodate these people, they said that this alternative site will be given. That has already been given. Compensation has been given. And what are the further things to be done? We will do it. That was agreed upon. Only to that extent. Now what they are saying is that, yes, now we will not vacate it. They are squatting over the government land. Is it permissible at all to protect such people who are squatting over the government land? And by virtue of an interim order, what is the damage that is going to be caused? Kindly take Ramanikal's case in 1996, Supreme Court. That is 1997, 1 SCC 330, under 226, whether such things can be done. That is 1997, volume 1, page 134.
1997 SCC.
Yes, 1997, 1 SCC, page 134.
134. Yes.
Have you given it? It's given to the court and the court must pay.
Therefore, he or she 97 versus without.
Before you go to the judgments,
Hmm.
page 83, just
Yes,
complete
yes,
the
yes,
top.
yes, I'm taking.
Last three lines.
Yes,
The sub-collector, 83, page 83,
page 83, yes,
83, which
Yes.
you are reading,
yes,
in between, after 4 lines,
Yes.
sub-collector also informed that
yes. Also informed that in response to his letter asking for compliance by MCLC, the company authorities had informed about the concrete action taken by them towards making the land hassle-free.
yes.
He also explained about the legal frame of settlement, the relevant provisions of RN policy. He stated that the resettlement site would be finalized by the so and so in consultation with the landlords. That's all.
That's what we want to
Yes.
know, that the RPDAC has approved or not, that's all.
That's all. That's on facts. He will.
If it is approved, then end of the matter.
When I was discussing, it has been approved. It has been approved.
Because the agreed terms also says that
So
it's
this is
subject to
a
approval.
2014
Uh,
letter. This is a 2014
RPDS.
letter, 11 years back. No. This is a 2014 letter, Miller.
No, this is agreed terms.
Yes.
This is agreed terms.
Now,
This
this
is
is connecting the entire, this one, the what has been agreed. Now, please look into the prayer made in the writ petition in the context of what has been transpired. Now, kindly see 4 prayers. Yes. Yes. That's at pay number
38.
Yes, part of the affidavit that is the writ petition pay.
Why the
Why
letter?
a letter dated 31/7/2014 to the extent challenge in the writ appeal shall not be quashed. That is what remains was only the last para. The deadline was fixed there.
Which you read it?
Yes, only to that extent.
Yes.
Why the opposite party shall not be directed to reinstate the services that is already done. Second prayer. Then why opposite parties shall not be directed not to take any coercive action against the petitioner till they are allotted plots physically in the resettlement site, so and so. Sites have been allotted in terms of the agreed terms. Then what more we want to do it in the present writ petition in the appellate stage. The approach in the writ appeal would be not to inquire whether the lawless single judge was right. You have to see whether lawless single judge was wrong. That is the approach in the intra-court appeal. Now, please take that Ramanik Lal I pointed out. I'm sorry, have you got it, Court Master?
Do you have copy? Would you just
No, not brought it. What is this? I told in the morning.
1996 to SSC.
It's here, it will just.
Yes.
This is.
One SSC, 1997.
97 1 SCC.
That's the scope of the.
Not scope. In these kind of matters, what should be the approach, and by granting some kind of interim order, what are the hindrance you are going to cause to this one, the entire, especially that was in the context of land acquisition that was given. Here it is, acquisition is over. We are one step ahead.
1997. Volume 1. This is page 134.
Last.
Sleep and get side effect.
You are right.
Yes. Which paragraph, sir?
Kindly go to para 10. Proceedings should not be obstacle. Our country is now launched upon the ambitious program of all-round economic advancement to make our economy competitive in the world market. We are anxious to attract foreign direct investment to the maximum extent. We propose to compete with China economically. We wish to attain the pace of progress achieved by some Asian countries referred to as so and so. Then the means of transportation, power and communications are in the dire need of substantial improvement, expansion and modernization. These things are very often called for acquisition of land, and that too without any delay. It is, however, natural that in most of these cases, the persons affected challenge the acquisition proceedings course. These challenges are generally in the shape of writ petition filed in the high courts. Invariably, stay of acquisition is asked for sake, and in some cases, orders by way of stay of injunction are also made. Whatever may have been the practice in the past, a time has come where the courts should keep the larger public interest in mind while exercising the powers of granting stay or injunction. The power under Article 226 discretionary. It will be exercised only in furtherance of the interest of justice and not merely for making out a legal point. And in the matter of land acquisition for public purposes, the interest of justice and public interest collide. They are very often one and the same. Even in civil suit, granting injunction so and so or particularly interlocutory nature is equally discretionary. Courts have to weigh the public interest vis-a-vis the private interest while exercising power under 226. Indeed, in any of their discretion powers, it may even open to the High Court to direct in case finds that finally the acquisition was vitiated on account of non-compliance with some requirement that the person interested shall also be entitled to a particular amount of damages to be awarded as a lump sum or calculated so and so. These are many ways to affording the appropriate relief and addressing the wrong. Quashing the acquisition proceedings is not only mode of redress. To wit, it is ultimately a matter of balance, so and so. Now, it is something more. What you are doing is there is an interim order. Acquisition has become complete. Now, by way of an interim order, again you are stopping the acquisition for the purpose of which the land is acquired.
Now,
It is much worse than that. It is much worse than that now. The acquisition is complete, land is vested, compensation is paid, sites are paid, still there is an injunction. Yes, you don't do it. The crores of rupees of public interest, the public money, it is being wasted. The entire power generation is affected at the sake of, at the cost of the few people here. And whatever the further thing to be done in terms of the plan or thing, kindly direct us. We are not against these people. Definitely, I will instruct the concerned officers to provide whatever the further amenities to be provided. We'll do it. Kindly record it as an undertaking from us.
Solicitor General is giving, can it come by way of an affidavit from the,
So you
Whatever.
strike a balance, your undertaking will record it.
We have given so many affidavits already on record.
if anything has
If
been
the-
left out?
We will do that, your lordship may direct whatever.
That's what. It's better.
But entire this affidavit is very exhaustive. We have stated.
No, we'll file one more
Yes,
affidavit, no problem.
See, if they are
File one more
not
affidavit.
satisfied, something has to be done.
Yes,
It has to be
yes,
done as
we-
simple
we-
as
that's
that.
all.
Yes,
Instead
sir,
of
we are
going
not
into all
opposed.
this,
We are not
different question
opposed.
of facts.
Actually, by portion.
Strike
and
a balance.
portion-
We do not
Yes.
want to. They are the people, their lands have been acquired for our purpose. We all.
We will do that, Miller. There is no objection to that.
Some assurance has to come on record,
That's
that's
right.
all.
No, that will do. That will do.
Some assurance by way of an undertaking, by way of an affidavit or something of that
Can it
sort.
be filed during?
All right, we'll file an
During the
affidavit.
course of the-
During course of the day.
We'll do it.
We'll file
And
it.
the collector is there, he can assure the.
We will
things
file
are
it
done
during course of the
in
day.
right
We'll
perspective, that's
discuss.
all.
Yes.
That's the
So that will be a striking of balance.
balance between the two.
Your lordship may close it. We'll be filing.
If,
In course of the
because
day.
if anything in terms of that
Yes.
particular provision that, what is that?
7-2.
Seven.
7-2.
Seven.
That, Miller.
Complex
We are
7-2,
agreeing
that's
with
all.
You have
Yes.
given the completion certificate, but if anything has been pointed out to you that these are being left out, then definitely that will be addressed. So that affidavit should come.
What is the statute demands that 7-2 compliance, you will give a completion certificate that precedes a approval from PADAC, the committee. RPDAC committee. That approval is not there on record. That's the, otherwise you have complied, there is no problem in it. But that approval should have been there on record.
My lord, I think the references to the 2014 RPDAC proceeding, my lord.
20.
After that, the matter has been agitated in multiple RPDSCs and these issues.
No, no,
have
no,
been taken.
the.
What was the last one?
Once you have written in this letter dated 10/6/2025 to the general manager, which has been annexed to that annexure H, that shows that there is something more to be done.
Done.
And you are, please see that letter.
My lord.
It is your letter addressed to general manager MCL.
No, H.
Sorry, annexure
What
H,
paragraph is
that
very
is
important?
dated 10/6/25, and the last paragraph is very important. Therefore, it is imperative that the provisions of so and so are complied with in full to avoid any future legal and procedural complication. You are accordingly requested to furnish a comprehensive completion certificate of Balanda RR site within 7 days to enable necessary consideration at the end for issuance of certificate so and so. So whether that comprehensive completion report has received by you, for which you give such certificate as has been filed.
Final completion certificate. will go.
Yeah.
On the what basis you have given? That's not coming forth in the letter.
Because in June you are writing.
PDS plan karibo, the plan ta comply hai like nahi, but report.
Let us not stand on any technicalities, whatever they want, actually,
No, that's-
on the
that-
ground report, we'll
Because
meet and complete
because
it, that's all.
collective is here, that's why we are asking him that.
Will not go by the letters of the what. In the ground it has to be done. That's all.
That's all.
Now, we have indicated something, let us take note of in the today's affidavit, page 5. Today's affidavit, page 5, paragraph 10.
You want something more?
No, sir, we are fair enough to concede to a lot of things.
No.
We are fair enough to concede. On merit actually that 97 Supreme is not applicable here.
No, it's all.
I'm not
What we,
commenting on that. Para 10 what should we kind of see?
Mr. Mishra, you must have seen that lotus flower or the lily flower, when it's in the pond and the water level goes up, the skin goes up to that. That one day what happens, that water level recedes. Then he cannot adjust, come down. So it has to be broken. So that is how now, once they are going on fulfilling your demand, you are raising it to a higher level.
Absolutely not.
What my brother is saying
Yeah.
that don't be very ambitious.
Exactly. Kindly look at the proposal.
Whatever you are
Kindly
getting,
look at the
you should
proposal.
be happy with that.
Sir, kindly look at the proposal I have given.
Last one, completion certificate.
Para 10 now.
Para 10 of your affidavit.
Today's affidavit,
Yes.
page 5, para 10. The appellant submitted
Number 10.
following demands.
5 no page.
Each is.
हाँ, it है, 5 खड़ा.
वो फिर आपको कुछ और भी एक लिस्ट दे दिया क्या क्या
Okay, okay.
Let a fresh charter of demands.
Sir, just a
Try
minute,
to
sir, let me
detail.
read it.
It's not in the policy
We
mill.
are not telling this, just he has pointed out.
Expedite and timely completion of the work at the resettlement site as per the approved plan. Am I clear, my lord?
Yeah.
That is what is required for giving a completion certificate.
Within a period of 6 months.
Preferably within a period of 6 months
Okay.
or any time less than that,
Okay.
Okay, then.
right?
To provide company
Two,
water.
To provide company quarter as transit accommodation for 27 number of appellant within a period of 1 month, that they are not given.
Okay.
Out of 154, only 27 are left out. Though with much difficulty, some are accommodating.
Okay, next.
Yeah.
Expeditious disbursement of.
So 25, let's say take note 25, not 27.
Okay, 25.
They're wrong typing.
All right, next.
Within a period of 1 month, subsequent to which the appellant shall vacate their land. Have indicated. Third, expeditious disposal of house building assistance, 3,93,039, which they have agreed in the meeting also.
Okay.
This is a 2024 going out of this one.
Itself.
Yes.
It is actually the Advocate General I'm addressing. Ninth biennial revision resettlement grant, monetary term resolution 18/11/2024. I filed it, madam. The resolution has been filed for your lordship.
Okay.
Then incentive for early and expeditious displacement, PDF, 10 lakhs. Has been the decision taken in the 12 RPDS meeting. It has been taken in the meeting, sir. I am not saying exaggerating anything. So these are.
No, it has not been decided.
Sir, the meetings.
You are putting that demand. That doesn't mean that every demand would be fulfilled.
Minutes are there.
A demand is not in the nature of, it is not a part of the policy. You go on demanding, give us 10 lakhs more,
They have
give us
implemented
14
it,
lakhs more for construction of house, give us Whatever
You
is
cannot
below
implement
is
for X, you
provided,
cannot
it's in
implement for Y.
2014 acquisition. They go on below forcefully occupying the land and the houses, and they say that in 2025 you go give us money now. This is the market rate, etc. How can that be done?
But Learned Advocate General, so far as the 1 and 2 are concerned,
They're perfectly fine.
Perfectly fine, we'll do
Perfectly
that.
fine.
do that. You do it, that affidavit which you are supposed to
Yes.
file.
1,
Yes.
2 and 3. What?
Or 3, we do not know whether they have agreed or not.
No, we have not agreed, Miller.
Statute requires, sir, it's not agreed. But the statutory provision.
Whatever is required under the statute, even if it has
No, no,
not
what-
been done, it
what-
will be done.
Even,
No, even if whatever is required under
Again,
statute,
whatever-
Miller, we undertake, if it has not been done so far, it would be done within a fortnight, a month,
All these.
a month. Your Lordship, yes, we
That
give
is
that
there,
under.
general statement also.
Whatever is spelled out in the policy, Miller, even if something has been left for their composition,
Affidavit which you are supposed to file,
yes,
please mention specifically about Roman 1 and Roman 2.
Roman 2, we'll do that.
And that line which you are saying that if,
That's
as
right.
per law,
All the statutory.
all the statutory, that
And
That
that
we will be doing within a month. Your Lordship.
That's right, perfect.
Yes,
1, 2.
under the policy,
1,
not
2
beyond it.
specifically and all.
Yes.
sir, kindly turn to page 22 in that affidavit.
Your affidavit should be
Just a
endless.
minute, sir.
Every day they are coming with an
Sir, you
affidavit,
came
we
with
are
a
filing.
report,
Yeah, just.
Naturally.
Which one?
Page
If you
22,
are filing,
annexure
we have to
3.
be
20?
in this.
2, annexure 3.
Yeah.
So this is a resolution of the Government of Orissa Revenue Adjustment Management Department. The clause 1, 2. 1 is assistance of self-relocation. We are not concerned. House building assistance, referring to para 1, so and so, 3 lakhs, 12,465, which has been enhanced to 3 lakhs, 39,383.
It's it, November 24. You can't antedate it, retrospectively
Yes, sir.
apply it.
Display.
How can you not? His acquisition is over since
It is
2007.
We will not go into, whatever you are entitled, you will get it. That's all.
Naturally, but it's a November 24 resolution. But they say that it should also be applicable to an acquisition proceeding completed in 2007.
Whatever you are entitled under the policy, you will get it. That's all within 1 month.
It doesn't apply retrospectively.
To the people who have not been paid.
No.
Please file that affidavit today.
Yes,
We are
yes.
closing
We'll
it.
find it. It doesn't apply to
Sir,
it.
I will request your Lordship one thing. So, please don't misunderstand me.
No question of misunderstanding, Mr.
Sir,
You are railing.
let him file an affidavit with a copy to me. Keep it pending, Lord.
No, let it be closed.
Sir.
Every day, a writ appeal cannot be milled for last 10 years.
See, we are
10
agreeing,
years
see,
old.
the writ appeal, we are ready to.
10 years,
MS,
milled. 10-year old.
directing them to do something,
Yes.
even in the writ appeal.
That's
Otherwise,
correct.
we could have
That's
confined
correct.
ourselves to writ appeal.
Continuous mandamus in appeal. Continuous mandamus in appeal is not at all
Again and
permissible.
again,
But still, we are doing because to strike a balance so that.
We're
things
not
will be-
anti people.
Reason-
We
reason
want to
being,
do
sir,
something if it is
The
to.
question of the villagers will resolve public. So they are not going to be affected. They have waited so long, but they have not done it.
Villagers are milled, not litigating.
They are giving.
Villagers are just the milled.
Sir, don't make comments.
Yes, no, it is true. Let us, the collector is here, you ask, what is the ground reality?
But your Lordship has said.
this affidavit should be from one responsible officer.
Yes, we'll do that from the MCL.
One,
we'll
two,
do.
and
It should be vague, it should be some assurance should flow
absolutely,
from the affidavit.
and the time limit.
Time. Milled by 4 PM we'll find it.
The assurance has to flow from the affidavit itself.
This
That will do.
these two.
1 and 2 in
within this
particular,
time.
1 and 2 in particular, in addition to whatever statute requirement that will be complied.
And it will be also within this period. The first one, they say about 6 months.
Yes.
The second one, they say that's quarter for 1 month.
Right.
That
Right.
you do, other things just.
Correct.
Like,
Please,
the
please.
affidavit should be given to us.
Yeah,
Naturally,
definitely.
obvious.
Given to-
Sir, let me be candid in my confession to the extent that, sir, now by filing the affidavit or the case is closed, they cannot tomorrow go and evict every person and demolish the houses. But they have.
The houses are in a unsafe condition. They are not staying there. Milled, nobody is staying there. Huh? Nobody is staying there, milled. It's in a unsafe.
One second. Let him say how much time he wants. Let him say.
You have framed
I have indicated that.
that time.
That is the same time, they will give, same
The
time,
affidavit I have given.
same time.
Advocate
Same time,
Commission
6 months,
report
1
says
month.
it is unsafe. Milled, the administration
Whatever
to
the
be blamed,
time
the
is-
government to be blamed.
He
But nobody is staying there, Milord. Nobody is staying. It's all, Milord, dilapidated, deserted.
Mr. Mishra,
Why
once
are
you
you
say that only 25 persons have not been provided accommodation in the transit house, that presupposes that all other have been provided.
That's
That's
absolutely.
what I say.
So the
Right.
raised 25 will be provided within
Within
1
1
month.
month.
They have
Yes.
given they will file the affidavit.
That's
What more
correct.
do you want?
Second is that the relief settlement site has to be completed within a particular time.
That they have
6 months you have gained.
6 months you are agreed to that.
6 months.
What further you?
And whatever dues we are entitled to, they should.
That statutory entitlement, they give the three
That
things.
we are saying that.
Statutory entitlement,
This
entitlement. you-
27 Milord subject to eligibility. We do not know whether they have
Obviously,
taken or
that's,
natural.
that need not be.
Subject to eligibility.
If they are not eligible,
Outsiders are coming demanding
They are-
quarters.
Simply.
Many Milord strangers are occupying MCL quarters.
This is the game they are going to play.
No, there is no
But they
game
are
at all.
going to
You
come
have
out
been
with
playing
the-
the game for the last 10 years.
But-
There is no game from outside.
But till they
How
are
do
not
we-
disputed that these 102 are not.
No,
entitled.
please.
See, every
at
game,
least like-
game cannot be sorted out here in this taping.
No.
You play game, they play.
Unilaterally playing the game. We are only the onlookers.
Till now.
You are a very good game player. You are a cricketer. You
Now
know how
only
to
25.
roll the ball in the
They
field.
have not disputed. Now say eligibility. So they'll say
Please,
this 25 is
Mr.
not
Mishra,
entitled.
Mr. Mishra, you have given that number of persons list at annexure 2, page 21.
Yes.
So these are the persons. So let us say, this is your list.
Yes.
Suppose they will find that there is no such house of
Right.
these persons who are not residing. They are not at all entitled. They are strangers totally. How can, we are
Sir,
saying that
absolutely.
verifying, it
Now,
will be
these are-
verified if that is
These
entitled.
are the person
Yes.
who have given the plot number and also they are in the rate.
Then they will definitely give, the
Yes.
plot number has been given, though, that is why we are just opening up. You are whosoever is entitled to get it, and the number of 25 persons you have stated,
Yes, I've
that
given.
is to be provided, the transit accommodation is to be
Right.
provided within 1 month. That affidavit will be very specific. to
Yes,
that.
Milord, yes. We'll do that.
Yes.
We'll do that.
Eligibility will be decided by the actual authority, the collector is there,
Right.
they will do it.
Milord, we are not unfair.
And-
Milord, let us
Till
be
the-
very
Not
Yes.
expected that you should
And
be.
till that 1 month, they should not actually demolish.
1 month you have given time.
Kind of time.
Time you have given. 1 month.
Unless they provide you the transit house, they cannot
Right.
proceed that.
So that is what's like.
So,
Yes, yes.
let me do, what is that? Mr. S.P. Mishra and Senior Advocate appearing for the appellants, and Advocate General. Okay, कहाँ नाम लिखा मुझे?
Mr. Advocate General, can you please give the name of
Milord,
the officer? those are-
27 subject to eligibility, because
That's
if
right.
father has
That's
taken,
right.
now the son is demanding. Also give us
You
an
please
accommodation.
give the
He has
appearance of the
become agent.
officers, those who are present.
No, that's subject to,
Sir,
yes. They have been
There's
doing
a
that.
New game plan there.
Milord, a person who was born in 2006, at the time of acquisition, he has become 18, 19 years old. They say that you also provide them house, accommodation, job,
They are
everything.
entitled to employment, sir.
No. Employment you have has already been given. Father, son, grandson, everybody cannot be given employment.
We are writing that the affidavit
Yes.
has been filed by so-and-so, which is taken on record. Copy of the affidavit has been furnished to Ms. We are writing it, so, take, and, also heard Mr. Kim, and Additional Solicitor General of India, okay? The hearing is closed, judgment is resolved, okay? In the beginning, that Mr. S.P. Mishra and counsel appearing for the appellants filed an affidavit pursuant to the objection affidavit dated 2/9/2025 filed by the respondent, which is taken on record. This is the affidavit. And so and so officers are present. During course of argument,
Give the name.
the Mr. Mishra pointed out that in page number 5, that regarding the terms of settlement and demands raised by the appellants, the land advocate general, also Mr. Nataraj, is fair enough to say that an affidavit will be filed by a sworn responsible officer, in which they will appeal, it will be mentioned
MCL.
that this clause number 1 and 2 will be fulfilled within the time limit as required by the so and so. Subject to, so far as number 2 is subject to eligibility and other entitlement which they are entitled as per the RR policy.
Your lordship may say
Subject to
that.
entitlement is a individual cause. If you have an individual cause, you hesitate.
Right,
right.
right.
Individual, suppose you are rejected, one person is rejected, that is the individual
Individual
cause, you
cause of
can hesitate according to, in accordance with
Your
law.
lordship may clarify that they should immediately, they should not create any obstacle. Because taking advantage, they are telling, no, that's correct. That is they are creating law and order situation. No, ଆରେ ଆମେ କଣ କଳିଙ୍ଗନଗର କରିବୁ କି ଚାହୁଁଛନ୍ତି ଆପଣ ଯେମିତି କରିଥିଲେ no we can't afford to do that ନା ଆପଣ ମାନେ କରିଥିଲେ ଆମେ we don't want to repeat that ଆରେ obstruction କରୁଛନ୍ତି ହେଲା ମାରୁଛନ୍ତି ଅଫିସର ମାନେ ଗଲେ ଫୋପାଡୁଛନ୍ତି କି କଥା
କିଏ ଫାଇଲ କରିବ affidavit କହୁନାହାନ୍ତି?
there should be Millard peaceful
File the affidavit.
Millard Sanjay Kumar
Sanjay Kumar and Sanjay Kumar De, Chief Manager, Mining, Public Staff Officer, L&R, Bhubaneswar area, MCL, for file an affidavit, has filed an affidavit.
by Millard end of the day by 4 p.m.
Yes, today you file and give the, we have taken that on record. So it should be on.
Millard, that should be peaceful, your lordship may indicate that. Peaceful vacation of the premises. Otherwise, Millard, that is creating problem for the administration. Yes.
Mr. Mishra will not go that way.
He doesn't, he's very decent that way. He's my,
So
Mr. Mishra is decent that way.
remember that the thing by the side while taking food.
Christian Millard, police.
So I
Millard
think
is of
only
police.
they have pointed out only 25 persons are behind.
Right, if they are entitled, we'll immediately
I
do.
think once they go to that place, this will be vacant. And
That condition you will
It should
accept.
be little compassionate to
Yes.
us.
Millard, no, yes. We are entirely in agreement with.
We'll indicate that.
Deeply.
Okay, thank you, Mr.
Please, I'm
Mishra.
grateful.
Millard, we are grateful for putting an end to a decade-long litigation, a 15 writ appeal. Millard, we are really grateful.
No,
Deeply.
thank you.
I'm grateful.
Grateful.